Evet, herkese bir eşitlik arayışında daha merhaba. Artık gelenekselleştiğini söyleyebileceğimiz bu programda bugün Tarih ilkeleri ışığında eşitlik konularının rolünü konuşuyor olacağız. Tarih ilkelerinin 20. yılı doldu ve gerçekten yeniden üzerine konuştuğumuz bir mesele haline geldi. Hem Türkiye'de hem pek çok ülkede. Bugün çok önemli bir konuğumuz var. Tamás Kádár bizimle birlikte. Önce kendim de onu tanıtarak başlamak isterim. Öncelikle Çiğdem Sever, Eşitlik için Derneği'nin de aynı zamanda bir üyesiyim. Ve bir süredir de eşitlik kurumları ve KDK gibi insan hakları kurumları üzerine de çalışmaya devam ediyorum. Atıl Üniversitesi Hukuk Fakültesi'nde doçent olarak görev yapıyorum. Değerli konuğumuz Tamás Kádár da aslında bu konuda tabii uzun yıllardır deneyimli olan bir konuğumuz. 2010 yılından beri EQUINET'te çalışıyor. Daha öncesinde de Macaristan Eşit Muamele Kurumu'nda hukuk uzmanı olarak çalışmış ve ayrımcılık alanında da çalışıyor. Önce hukuk fakültesini bitirdikten sonra ekonomi bilimi yüksek lisans ve daha sonra da İrlanda'da Dublin'de Üniversite College Dublin'den mezun oluyor. E, Bu konuda eşitlik ve ayrımcılık üzerine makaleleri, toplantılarda konuşmaları var ve aynı zamanda AB Avrupa Konseyi'nde eğitmen olarak ve uzman olarak da görev yapmış durumda. Ve parçası olduğu EQUINET üzerine o konuşacak elbette ama kısaca belki çok konuya dahil olmayanlar açısından bir giriş yapmak belki iyi olabilir. EQUINET aslında 2002-2004 yılları arasındaki 2 yıllık bir proje eşit muamele mevzuatının uygulanması için uzmanlaşmış kurumlar arasındaki işbirliğinin güçlendirilmesi projesi üzerinden kurulmaya başlanmış. Ve bir ağ aslında yapı olarak. Bu da 2007 yılında bir sekreteriyaya sahip olmaya başlıyor Göç Politikası Grubu tarafından. Ve 2007'de gerçekten Brüksel'de sekreteriya oluşup Belçika yasaları uyarınca bir dernek statüsüyle bağımsız bir yapı olarak kurulmuş durumda ve elbette eşitlik kurumlarının daha aktif hareket edebilmesi için onları desteklemek ve biraz bu konuda belli standartlar geliştirme, bu konuları güçlendirme konusunda önemli rolleri yerine getiriyor. Ve sadece tabii ki bu ağ işlemi dışında mahkemelere uzman görüş sunma, belli standartlar geliştirme, özellikle erişilebilirlikle ilgili. Ve bir yandan da dezavantajlı gruplar önündeki adalete erişim konusundaki engelleri aşma konusunda önemli çalışmalar yapıyor. Hoş geldiniz tekrar Tamás Kádár. Ben bundan sonra İngilizce devam edeceğim diye söyleyeyim. Welcome, Tamás Kádár. We are really pleased to be with you here. Okay. Now we do have some questions also for you. Firstly, maybe you want to talk about Paris principles and EQUINET, the mission of EQUINET. Welcome again.
Sure. Thank you very much, Çiğdem. And thank you for the introduction and welcome to the participants of this webinar. I think I was really properly introduced, so I won't go on further, but it's a pleasure. Just to say, EQUINET has 48 member organizations, all public institutions from 38 countries at the moment. And well, it's interesting because EQUINET and equality bodies are not directly based on the Paris principles that you mentioned, Çiğdem, because the Paris principles were adopted for national human rights institutions, as you know, and they are a product of the UN, the United Nations system, whereas equality bodies, and that's a major and important difference, that equality bodies are essentially the product of the EU system. So they are based on EU legislation. Equality bodies existed also before the EU legislation was adopted, but we can only talk about a widespread presence of equality bodies in Europe since 2000, when the first EU legislation in that regard was adopted. And I can talk about that later, of course, also what does that mean and what are the different standards for equality bodies. But just to sort of verify that the Paris principles, of course, still have some relevance, not the least because some of our members are also national human rights institutions. But even for those members who are not, it does have a relevance because, especially until we did not have specific standards for equality bodies themselves, the EU directives say very little. And until we didn't have anything else, it was really useful to refer by analogy to the Paris principles.
Thank you very much. And now I want to focus on these type of institutions, because we all know that the establishment of these kind of institutions has become very important issue in human rights law, because the courts in protecting human rights can sometimes have such shortages, especially in the discrimination cases, as we experienced in every country, I think. And very strict procedural and evidentiary rules are particularly problem in the discrimination claims. And they are expensive, time-consuming, and information-intensive instruments, such as access for justice instruments for disadvantaged groups are also a specific issue in human rights nowadays. And for I know there are differences between Paris principles and equality bodies, but especially some key pillars are very similar in terms of pluralism, independence, and effectiveness. And today, how do you evaluate the role of these kind of institutions to protect human rights, especially in difficult times and especially for disadvantaged groups?
Yeah, I have prepared a presentation about equality bodies and about the different types of standards that they have to adhere to in order for them to be able to effectively help victims of discrimination and promote equality. So maybe if you allow me, I will now share my screen and try to share that presentation, hoping that it will be useful. So basically, as I mentioned, equality bodies are independent national public institutions, and they are assisting victims of discrimination and promoting equality. This is the baseline, and I think that Çiğdem, you already referred to some of the main reasons why we have equality bodies, starting from. I think the overall picture is the difficult access to justice for persons who have been discriminated. And this is yet again, I think, a difference with at least some of the national human rights institutions, because according to the Paris principles, it's not absolutely necessary for the NHRI to also provide assistance to victims. Whereas for equality bodies, this is really at the heart of what they do. It's a really important part of their work. As I mentioned, the equality bodies are based on EU directives, which were adopted in 2000, 2004, and 2006, and according to which all the EU member states must designate one or several equality bodies. To cover some of the grounds, actually, according to the EU legislation, it is only compulsory for equality bodies to be set up on the ground of gender and on the ground of race and ethnicity. But many member states and also accession countries decided to go beyond that and also give a mandate for their equality bodies to cover other grounds of discrimination that are in the EU treaties, like age, disability, religion or belief, and sexual orientation. So, and here I think I also come to the importance of what is the potential of equality bodies, what is it that they do? Essentially to promote equal societies and to fight discrimination. So that's a positive and a negative aspect of their work. They are fighting discrimination that has already happened, and of course also trying to prevent discrimination, among others, by promoting equality in society. So one of the things that they do is, and that is quite well-known function of equality bodies, I think, is taking complaints from victims of discrimination and also providing legal assistance to victims of discrimination, which can mean taking cases to court or deciding cases in their administrative procedure. This really depends on the national model that exists in the countries. And beyond that, they also do a lot of other types of work, such as collecting data on equality, conducting research on equality in society, making recommendations to policymakers and legislators. So this is really on bills, on legislative proposals, but also general proposals in their annual reports, for instance, to change certain policies and legislation. They also do awareness-raising work and communication work, and they also work with the duty bearers of equality legislation, such as the employers, those who are providing services, and also the public sector bodies and civil society organizations. And they do that in order to help them put in place good equality plans and practices. So again, that's a proactive work, trying to work with those who may at some point discriminate, to prevent this by adopting good practices and good policies in these institutions. I'm not going to mention this because you did already. What is EQUINET? It's the network of equality bodies in Europe, and this is essentially what we do. So maybe I could have started with this, but I prepared the presentation before you introduced EQUINET. In terms of, I think it's also interesting to see a little bit that, as I mentioned, there is a big diversity among equality bodies in Europe. So there is no one model. There are some equality bodies which only focus on equality issues, which do not have any other mandates, while others actually have other mandates. And this is what I said, that some of them are also national human rights institutions, or some of them are also ombud institutions. And some of them are all three of them, actually. Like the Polish Commissioner for Human Rights is an equality body, an ombud institution, and a national human rights institution. The size can be really, really different as well, ranging from 3 staff members in Luxembourg, for instance, to more than 200 in France. Even though it has to be said that the Defender of Rights in France is also a multi-mandate institution, so they are also an ombud institution, which explains a little bit, and the size of the country, of course, also explains the large size of the office. But I have to say also that, for instance, Germany, which has an even higher population than France, so in Germany, the equality body has around 40 staff members, so much, much smaller than the equality body in France. So there is a correlation, perhaps, between the size of the population and the size of the equality bodies, but not necessarily an automatic correlation. There are also differences in terms of the grounds covered. So many of the equality bodies cover multiple grounds of discrimination, but there are some of our members which only focus on race or ethnic origin. In Spain, for instance, only on gender, for instance, in Belgium, or only on disability, for instance, in Malta, Austria, and Croatia. We have equality bodies that only focus on the ground of disability. And in these cases, there is typically another equality body or even more than one equality body in the country, just to ensure that all grounds of discrimination are covered. In terms of the functions, there can also be quite different, because some of them focus more on helping victims take their cases to the court. As you mentioned, Çiğdem, this is not an easy process, and it's certainly seen as helpful to the victims of discrimination if they have someone who can help their case, who can represent them in front of the court, or at least give some advice, give some legal advice. So some of them focus on this because of the national model and the way they were set up, and others can make decisions which can be legally binding, like in Bulgaria, Hungary, or Romania. But it can also, we also have some examples of legally non-binding decisions or recommendations in the network. And last but not least, there is also diversity in terms of having or not having regional or local offices. Some of the members do have, and some others are only situated typically in the capital of the country, and then trying to ensure that they are accessible to everyone, despite this. And then I think, I don't know if you want me to stop here. I can also talk about later on the standards for equality bodies, which is going to be very important, and in a certain way, it is going to go beyond the Paris principles. So maybe I'll leave it at that if you want to come in at this point.
Bundan sonra Türkçe konuşmam gerektiği söylendi. O yüzden Türkçe'ye döneceğim. Tek çevirmen olduğu için ses farklı olmuyormuş. O uyarıyla başlayayım. Aynı ses olmasın diye bu şekilde devam etmek gerekiyor. Tam kaldığımız yerden aslında bahsettiğimiz gibi işlevsel olarak görev tanımı ve yetkiler bakımından farklılaşmakla birlikte eşitlik kurumlarında en önemli unsurlardan biri bağımsızlık olarak karşımıza çıkıyor. Elbette bağımsızlık için tek kriter olmamakla birlikte özellikle bağımsızlığı sağlamaya yönelik ne gibi standartlar ya da ne gibi iyi uygulamalardan bahsedebiliriz?
Yes, so I can continue from here. Thank you for giving me the right question. So indeed, I think independence is crucial, because without independence, equality bodies cannot really be effective in promoting equality and especially fighting discrimination, because it's quite simply a question of trust on one hand. So those who are discriminated might not want to turn to them if they are not seen as independent institutions. So there has to be a real independence, and the equality body also has to be perceived, has to be seen as independent by everyone. Because if it's not, then they will not bring their complaints to them, which of course means that we will not get to see all the complaints, we will not get to see the full picture, and equality bodies won't be able to help those who they were set up to help. And also I think it is a crucial issue because independence, let's be clear, it mostly means independence from the government and the politics. And quite often, it's the public institutions, it's the state institutions that discriminate. Not all the time. And of course, there is a lot of discrimination also in the private sector. But for sure, the experience of our members suggests that there is a lot of discrimination happening from the state or by the state. And if the equality body is seen as just another state institution, then why would anyone who thinks that their rights were violated and they were discriminated by some state institutions, why would they turn to another state institution? They would not trust them, especially if they come from a group which is already vulnerable or deprived of their rights, for instance. So independence is crucially important, but I think it's also very important to see that it's a system. It's a delicate system, and you can see on the slide mention of independence, resources, powers, mandates, and accessibility. And I think it's crucially important to provide all five of these and to increase the independence, the resources, the powers, the mandates, and the accessibility of the equality body at the same time, because just increasing one of them is not going to be enough. Is not going to be enough to help them really do their job as well as they should. And I think that in terms of what's out there, I already mentioned the directives. So it was a crucially important first step by the EU to set up equality bodies, to require all the member states to set up equality bodies. I have to say that this was actually preceded by a general policy recommendation on equality bodies by the European Commission Against Racism and Intolerance, which is a body of the Council of Europe. So from the Council of Europe level, which adopted this general policy recommendation on equality bodies in 1997. So 3 years before the EU legislation was first requiring equality member states to set up equality bodies. This GPR, as it's abbreviated, General Policy Recommendation, was renewed, revised in 2017, so 20 years after its adoption, to bring it more up to speed with the new reality. And then very shortly after that, the European Commission, so again the EU level, also adopted a recommendation on standards for equality bodies. So that was a very busy half a year, I would say, with a new revised GPR from the Council of Europe's EQUI and the new European Commission recommendation. The fact of the matter is, though, that all of this, the EQUI, GPR, and the European Commission recommendations were, as the name suggests, recommendations. They are not legally binding instruments. And I think that this is really important to keep in mind, that simply this was something that member states were asked to take into account, but there was no obligation for them to do so. And this is very important, because when the European Commission was looking at the implementation of the directives, which first required the setting up of equality bodies, they also looked at how the Commission recommendation that was adopted in 2018, how that's being actually implemented, and how member states take account of that. And the finding was that member states were not really bothered to follow the European Commission recommendations, which gave the European Commission the impression and the idea that giving a recommendation for this is not enough. And this is how in the latest equality strategies that were adopted in 2020, 2021, the Commission committed to look into the possibility and the necessity of adopting legislation, a legislative instrument. And then this culminated in last year, the Commission adopting 2 proposals for directives on standards for equality bodies. And I will talk more about the legislative process at the EU level, but I think it's also really interesting to look at the European Commission Against Racism and Intolerance, the EQUI GPR number 2, because it's quite an elaborate instrument, and because it's not legally binding, they could be quite ambitious. So that's also important to see, that of course if you adopt an instrument which is not legally binding, you can by definition go beyond and go further than with legislative instruments. So what does the EQUINET say? It talks about the establishment of equality bodies. It talks about their mandates, the institutional architecture, and the functions, distinguishing between three distinct functions: promotion and prevention, support and litigation, and decision making, with EQUI requiring all equality bodies to have the functions of promoting and preventing discrimination, and supporting and litigating. And decision-making is seen as more of an optional thing, which the equality body does not necessarily have to do. And they also make some interesting distinctions, because they detect that there can be some conflicts or tensions between support and litigation functions on one hand, and decision-making functions on the other hand. Because in the support and litigation function, the equality body is really on the side of the victim, whereas in the decision-making function, they are supposed to be fully impartial, like a court, essentially. And these two, the being partial on one hand and being impartial on the other hand, can be a tension. So in practice, we also see that it very rarely happens. If an equality body has strong decision-making powers, they most likely are not going to litigate, or at least not a lot. This is not going to be their typical tool to use. So beyond the functions, the EQUINET also talks about resources and effectiveness, and also about accessibility of the equality body, and monitoring. On this slide, you can just see the whole system that EQUI has. So they also use, for instance, this EQUI in the monitoring, in the country monitoring that they have. So EQUI goes from country to country, and they also look at the country's performances. And for instance, in this cycle of monitoring that EQUI does, they also look at the implementation of the revised GPR number 2. So how the equality bodies are operating in the country. On the establishment of equality bodies and the mandate, the EQUI GPR requires that equality bodies should be established by constitutional provision or by a law passed by the parliament. And they have to have a mandate for the whole territory. They have to cover all the grounds necessary under EQUI's mandate. They have to cover the private and public sectors, and they have to have a broad equality mandate. And I think it's many of these factors are quite important, actually. For instance, if we think about ombud institutions, they typically cover public sector. Now, equality bodies go beyond that. So we can also see there are some examples around Europe where the ombud institution was given the equality body function as well. And there, it's interesting because for most of what they do, they are only dealing with the public sector in terms of maladministration and the rights of the citizens. But specifically on equality matters, they also have to cover the private sector. In terms of the institutional architecture, there is an acknowledgement that equality bodies may take different forms. As I mentioned, it's pretty much, as you can see, there is diversity in terms of the coverage of grounds. There is a difference in terms of being a standalone only equality body or having a multi-mandate institution, and then if so, then the EQUI-GPR requires that, for instance, if the institution is also an NHRI or an ombud institution, the equality mandate has to be effectively carried out, and it has to have enough focus in the work of the equality, in the work of the institution. There has to be a coordination between the different mandates that the equality body has, or the institution has, if it has more than one mandate. I already talked about the functions that the equality bodies should have. One thing I did not mention, but is very important, is the powers to obtain evidence and information. So essentially investigation powers. EQUI finds that also really important to ensure. In terms of the independence, they talk about the independence of the body, institutional independence, and operational independence, without interference from the state, political parties, or other actors. And the equality body should not be given instructions. It should not be subject to instructions by the government in terms of how they do their job. In terms of the leadership, there are provisions about how the leadership should be selected through a transparent, competency-based, and participatory procedure. The leaders should be protected against threats, coercion, and arbitrary dismissal. In many countries, there are discussions about to what extent equality bodies should have, the leadership of equality bodies should have functional immunity. And of course, the leadership of the equality bodies should also have appropriate remuneration. They should be elected for an appropriate or appointed for an appropriate time period. And in terms of the management and communication, the equality bodies should have the right to independently decide on internal structure, on the management of their budget, on the recruitment and appointment of their staff. And they should also be entitled to make statements, publish research and reports independently without having to ask for permission from the government, for instance. In terms of the resources, the EQUI-GPR requires sufficient staff and funds to implement all the functions with real impact. So it's not just the usual provision that equality bodies should be provided with sufficient resources, but it goes into the detail that the equality body should be able to implement all the functions that's prescribed in the EQUI-GPR and with real impact. I think both of these are really important considerations. The GPR also talks about the expansion of the mandate. So the equality body receives more functions, more tasks, then that should come with additional funding. Many of the other things I also mentioned, don't want to go through all of these, but equality bodies are also supposed to involve stakeholders in their activities. And in terms of the plurality that you also mentioned earlier, Çiğdem, I think it's also important that it's required that equality bodies basically should also reflect the composition of the society in how they are composed, and they should also serve as a model with regards to diversity and gender balance. This is also something that's in parallel, I think, with the Paris principles, where it's also important that the NHRIs should also reflect the pluralistic composition of the country. In terms of accessibility, free of charge, it always surprises me when that is even discussed, because I think that if the services of the equality body are not provided free of charge, then there is immediately a discriminatory element in it on the basis of socioeconomic status. So it would only be some people who can afford to turn to the equality body. So all equality bodies should provide all their services for free of charge. They should be accessible, which should also include local outreach initiatives and local and regional offices, according to EQUI. And they should also provide their services with different languages. And of course, they should also make reasonable accommodation for persons with disabilities. And in terms of the monitoring, as I already mentioned, monitoring the implementation of the GPR is part of the country monitoring and the country visits that EQUI conducts. Now, in terms of moving on now from this relatively detailed explanation of the EQUI GPR, I also want to mention that EQUINET, while all this was happening, from around 2015, we really started working on calling for more stringent standards for equality bodies, because we saw, especially around the economic crisis in the early 2010s, that a lot of the equality bodies were falling victim, and especially their resources, they were falling victim to budget cuts, and quite often those budget cuts were extremely severe and disproportionate compared to other public bodies. So it seems like as if the economic crisis just provided a good excuse for the government and the politicians to get rid of equality bodies. And I think that this also links very much to the one of the main questions of this webinar about what can equality bodies do in crisis situations. This is why it's really important that we have strong rules that can protect them, because if not, then equality bodies may be the first ones or among the first ones to fall victim to crisis situations. And we need to tackle that so that they can actually provide help in crisis situations. And this is why, realizing this, that we started working on developing a project on standards to measure and to ask for higher guarantees for the mandate of equality bodies, the powers, the independence, and the resources especially. So in 2016, we first developed a working paper on standards for equality bodies, what they should include. And then we continued the work, and we also, when we saw that there is now a revised EQUI GPR and the European Commission recommendation, we also tried with this project to look at what does that mean, how can they be actually implemented and monitored. So this is why we also started working on indicators for equality bodies, which culminated in this publication, which really just literally was published last week, measuring standards for equality bodies, indicators for self-assessment, which includes indicators for the mandate of equality bodies, mandate and powers of equality bodies, the independence of equality bodies, and the resources. Now, in terms of the European Commission recommendation, what it talks about is mandate, the grounds and scope that has to be covered, the functions of equality bodies, which is listed as independent assistance, independent surveys and reports, recommendations to policymakers, the promotion of equality, the independence and effectiveness is also part of the description of their mandate. And then in terms of the independence, they talk about resources, also complaint submission, access and accessibility, and the coordination and cooperation. As I said, this is a slide which just sort of comes back to how we got to the proposal of legislative initiatives on equality bodies. It was basically mentioned as a possibility in the strategies for persons with disabilities, anti-Semitism, anti-racism, anti-Semitism, and so on. The European Commission basically found that most of the issues which gave rise to the European Commission recommendation in 2018 are still unresolved. And that led to them adopting two proposals, which were necessary because there is a different legal basis. So there is one directive which is on Article 157 based on Article 157 of the treaty on the functioning of the EU. And there is another one which is based on Article 19 of the treaty on the functioning of the EU. This is necessary because the Article 157 regulates gender equality in employment and gives legislative power to the EU on gender equality in employment, whereas Article 19 is the general equality clause in the treaties and gives general powers to the EU to adopt legislation on all the grounds, on gender, race, age, disability, religion, and sexual orientation. So there is then one directive which only focuses on gender equality in employment, and another directive which focuses on all other grounds and fields, but it also includes gender equality outside the field. It's quite a complicated thing, and actually it was funny to see that we thought that when we first saw that the Commission came forward with two proposals for directives, we first did not really understand why this was necessary, and felt a little bit silly that we didn't know this was necessary or this is how it happens. But then it was reassuring to hear that it was pretty much a novelty to everyone, including the legal services of the Commission and the Parliament and the Council as well. So it's quite specific that we have two directives which are basically almost identical in their wording, but they are still not in the same directive. They are two different legislative proposals based on two different articles in the treaties, and this also has implications for the legislative method, because the gender equality in employment directive can be adopted with qualified majority, whereas the Article 19 directive, which covers all the other grounds as well, that has to be adopted with unanimity. So in terms of what's in the directives, it's a lot, but don't worry, it's a lot also of things that I already mentioned before. So the importance of this is that this would be the first ever binding document for standards for equality bodies. As I mentioned, the only binding instruments so far are the directives which foresee and require the setting up of equality bodies, but they don't go into the details of what these equality bodies should look like. So in terms of giving real standards and real description of what an equality body looks like, this will be the first instrument. They talk about enhanced competences, they talk about independence, resources, accessibility, consultation, and cooperation. They also give equality bodies investigation powers. They make it possible to engage in mediation or alternative dispute resolution process. They very importantly also give enhanced legal powers in discrimination cases and legal standing in discrimination cases to equality bodies, which is going to be a huge help, because at the moment there are equality bodies in Europe which do not have a legal standing, so they cannot help the victims of discrimination as forcefully as they otherwise could if they were given those powers. But besides all this, of course, the equality bodies are also expected to promote equality and raise awareness. So that's also part of the directives. They are also required to cooperate with the public sector and private sector and the non-profit sector as well. They are also required to collect data, equality data, so any kind of data which could help them to map the situation of discrimination in the country. And in fact, they are expected to regularly report on the state of discrimination in the country. And at the end of the directive, there is also a description of what the monitoring of these directives is going to look like, which is also of crucial importance because, of course, any legislation is only as good as its implementation. So it is very important that member states will have to report to the European Commission on how they are implementing this directive, and there has to be some sort of scrutiny by the European Commission. So where do we stand now? Two different processes. The Council was looking at the two directives in parallel. They were very, very active and quick during the Swedish presidency of the EU in the first 6 months of this year. So they adopted what's called the general approach of the Council, which is basically their negotiating position that was adopted on the 12th of June. And then the European Parliament was a little bit slower. They adopted a report in November, and that made it possible for the European Parliament and the Council to start negotiating on a final text, specifically on the gender equality in employment directive, because the other one is a different process, and there the Council has the final word, basically. But on this gender equality in employment, it's a co-decision process. So they quite quickly managed to come to an agreement on the 12th of December. And then the Committee of Permanent Representatives just yesterday, on the 20th of December, adopted this or accepted this compromise text. So now it will have to go to the Council to vote on it, and then it also has to go to the European Parliament plenary to vote on it. But normally, this after the adoption in the Coreper, this should be normally a formality, both in the Council side and on the European Parliament side. So we are really getting close to the adoption of this text, and yes, I'm actually very happy to be able to bring you such fresh news just from yesterday. It's really well timed. If we had this webinar yesterday, I couldn't have told you about the Coreper agreement yet. Just very quickly, a few last slides on what EQUINET did in this process, and how we were contributing to it and are contributing to it. Basically, we have a brochure, which you can see on the left-hand side of the slide, also about some frequently asked questions, where we also put forward the rationale for why it is necessary to adopt standards for equality bodies. We also set up a dedicated page on our website on standards for equality bodies, where we collect all the information, all the documents from EQUINET and also from the EU institutions. On the right-hand side, you can see a document which is called "Legislating for Stronger, More Effective Equality Bodies," key elements for and expectations from future EU legislation on equality bodies. That's basically a ambition paper. It's a paper setting out our ambitions, which was produced in 2021 when we saw that the European Commission is seriously thinking about adopting a legislative proposal. Then we felt it's important to tell them what is it that we think should be in this legislation, essentially. Then to help the process, we also produced a fact sheet on the litigation powers of equality bodies. That was a specific fact sheet because apparently the litigation powers gave rise to a lot of discussions in the Council. So member states, governments were really not happy, some of them, to have to give litigation powers to equality bodies. So we felt it was maybe necessary and useful to give some examples of such litigation powers and how they can be used. And then similarly, still on litigation powers, our legal working group at EQUINET produced a report on cases without an identifiable victim and Actio Popularis, which also contributed a little bit to this debate, because for the equality bodies to have the possibility to proceed without an identifiable victim, so in the own name of the equality body, that was also challenged by many member states. So we thought it's important to give some examples of that. Then moving forward, the European Commission's proposals for directives strengthening equality bodies, that was a position paper which we published right after the adoption of the proposals in December last year. And then we also developed some amendments and put it on our website. So you can find all this on the website of EQUINET, on this dedicated web page to standards for equality bodies, where we basically formally, with all the agreement of all our members, we put forward some amendment proposals for both directives. And then on the right-hand side, you can see this compilation of the indicators that I already mentioned. And in the middle, you see a question mark, which is not a mistake that I just left in the PowerPoint by error, but I actually did it on purpose, because that's just to indicate that we also did, of course, a lot of back-to-backroom discussions and informal meetings, and also some proposals that quite late in the process we tried to also provide some ideas for where compromise between the European Parliament's position and the Council of the EU's position can be reached. But this was not a document that was published on our website. It was something informal and confidential that we just sent to the Council and the Parliament just to help the process a little bit. So yeah, this is the presentation. Sorry, now I took a lot, but I hope it was still useful.
Evet, çok teşekkür ediyoruz. Sayenizde çok yakın tarihli haberleri de almış olduk. Ben de duymamıştım onu. Ben biraz bu standartların uygulanmasına odaklanmak istiyorum. Çünkü gerçekten bahsettiğimiz gibi eşitlik kurumlarına ilişkin bu standartlar aslında birbiriyle çok ilişkili. Yani bir kurumun bağımsızlık düzeyi, güvenilirliğini etkiliyor. İşte kaynağı olması aynı zamanda benzer bir kapasite meselesi olarak etkiliyor. Ve tüm bunlarla ilgili aslında erişilebilirlik kavramına odaklanmak istiyorum. Pardon. Çünkü erişilebilirlik bizim için eşitlik kurumlarında şöyle özel bir öneme sahip. Özellikle adalete erişimde dezavantaja sahip ve ayrımcılığa uğrayan grupların sesinin duyurulması aslında biraz da bir eşitlik kurumlarında önemli bir mesele bizim için. Ve gerçekten dünyada da baktığımızda insan özellikle bireysel başvurular gibi mekanizmalarda aslında gerçek gündemi göremeyiz. Yani pek çok görünmeyen grup aslında hiç o mekanizmalara başvurmaz ve ayrımcılığa uğramaya devam eder. O yüzden erişilebilirlik meselesi tabii bu kapsayıcılık açısından çok önemli bir unsur. Belki o konuda iyi uygulama örnekleri ya da somutta ne yapmak gerekir üzerine odaklanmak isterim. Sizin bu konudaki özellikle deneyiminiz iyi örnekler açısından.
Yes, thank you. I think that accessibility is really crucial, and as I said, um, just like the trust, if people don't have the trust to turn to the equality body, we won't see the cases, and they won't get the help that they are entitled to. Similarly, if the equality body is not accessible, then it cannot fulfill its functions. So I agree, it is crucial, and there are many elements and layers of this accessibility, I think. A first layer, I think, is that equality bodies have to be known. So there has to be awareness about equality bodies, that they exist, that they are out there, and in this as dedicated institution funded by the state with the public institution powers to help them. I think that within the EU, the Fundamental Rights Agency conducts surveys on the perceptions and experiences of discrimination of different minorities. Racial minorities, but also religious minorities, and I'm afraid that in quite a few countries, the equality body is not well known enough. So I think that there is a lot to do in raising awareness, and it's quite important and interesting that the directives also make it a task for the member states to promote and raise awareness about the equality body, which I think is crucial because it is written as a responsibility of the member state. So it's not putting all the responsibility on the equality body with their quite limited funding to raise awareness about themselves, but it's actually going to be also a responsibility of the member state. We shall see how that works, but in any case, raising awareness about the equality body, and of course also about the legislation itself, the equality legislation itself, is one crucial element. Then another element is physical accessibility. We still have some examples of equality bodies which are quite unacceptably not given physically accessible premises. So persons in a wheelchair, for instance, might have difficulty accessing the equality body, which is frankly a quite bizarre and unacceptable idea of what an equality body should look like. So full physical accessibility should be provided. That should be a given. This I think that accessibility is something that is probably never 100% fully there. You always have to audit and check whether you are fully accessible, because there are so many different types of impairments that one can possibly imagine and that people can have, and they might all require different types of adjustments to how the equality body is situated in the physical space, but also in the digital space. So how their online resources and their website is organized, and also how they are organizing their work, for instance, so as to be able to give easy to read materials to persons with intellectual disabilities, for instance, or give explanations as necessary. So there are really a lot of elements of accessibility, physical accessibility, online accessibility, and so on. there is also a challenge about equality bodies that do not have local and regional offices. As I mentioned, this is the case in some of the countries, and then there are those good examples which do have some sort of a local presence. And it can be done in different ways. For instance, in France, they have, which is quite a big country, even if it's not as big as Turkey, of course, in terms of the territory, but they have different equality responsible persons or ambassadors, basically, in the different regions of France. So if an equality body doesn't have the resources to set up actual offices, it's also possible to provide such services through local representatives, basically. But then there are also those examples where they do have local or regional offices, such as in Belgium or in Slovakia or in Bulgaria, for instance. But this is also really crucial. And yeah, like I said, I think it might be less crucial for a country like the size of Luxembourg, where it is possible for everyone to, or much more possible for everyone to go to the capital. But for a country the size of Turkey, for instance, it's I think a really crucial question that people don't have to go to Ankara or Istanbul to get their case heard or their complaint heard. So really, I think that this is a crucially important thing.
Evet, teşekkür ederim. Bir de şunu sormak istiyorum. Bu kurumların veri toplama ve izleme işlevleri, özellikle ayrımcılık başvurularında büyük resmi göstermesi açısından çok önemli ve bazı durumlarda aslında ayrımcılığı ispatlamak için de çok önemli. Yani sadece bunun toplanması, bununla ilgili politika geliştirilmesi değil, var olan ayrımcılığı göstermesi ve başvuruları güçlendirmesi açısından da çok önemli. Yani tabii şunu söyleyeyim, bu erişilebilirlik meselesi zannediyorum bütün ülkelerin tam olarak gerçekleştiremediği bir şey dediğiniz gibi. Ve burada belki yapılmayan başvurular nelere bakmakta bir yön. Yani aslında yapılan şikayetlerin, başvuruların niteliği nerelerden yapıldı, nerelerden yapılmadığı, kimlerin yaptığı, kimlerin yapmadığı önemli bir gösterge ve Türkiye'de açıkçası başvurular çok da fiili durumu yansıtmıyor şu anda. Yani zaten başvuru sayısı çok az ve daha çok kurumsal kapasite anlamında önemli bir yere gelemedik. Ama verdiğiniz şu örneği aslında bir de soru var, onunla bağlantılandıracağım. Aksiyo popülaris'ten bahsettiniz. Yani doğrudan belirlenebilir bir zarar uğrayan kişi olmasa da başvuru yapılabilir. Yani başvurucuların aslında çok genişlemesi anlamına gelen bir uygulama. Aslında ideal uygulamalardan biri sanki. Yani özellikle bazı gruplar açısından. Türkiye'de bu kabul edilmiyor. Mutlaka zarara uğrayan kişinin ayrımcılık başvurusu yapması bekleniyor. Resen inceleme kararı verilebiliyor. Şimdi soru var. Aslında bu sorunun neden geldiğini de bildiğim için soruyla bağlantılandıracağım. Gelen soru, EQUINET üyesi eşitlik kurumlarının özellikle seçim süreçlerinde nasıl bir role sahip olduklarına ilişkin. Özellikle işte seçme seçilme hakkında yaşanan ayrımcılıklarla ilgili Eşit Haklar İçin İzleme Derneği de faaliyetler yürütüyor. Ve burada işte zarara uğrayan koşullu olması nedeniyle pek de yol alınamadı açıkçası. Yani böyle bir örnek olduğunu bildiğim için söyleyeyim. Acaba eşitlik kurumları bu süreçlerde nasıl bir rol üstleniyor ve aksiyo popülaris uygulamaları biraz belki ne gibi etkiler yaratıyor bu kurumlarda diye sormak isterim.
Thank you very much. That's a lot of questions in one go, but I'll try to.
Sorry.
I'll try to. Very important and interesting ones. So I'll start from the equality data. Indeed, I think that equality data is crucial, and there is more and more of a recognition of the importance of collecting equality data across the globe, basically, and across Europe for sure. Because, as you said, without equality data, you don't know what's happening in your country. So this is why it's a really important element, and the Commission's proposal for the directives on standards for equality bodies also requires, also sort of acknowledges this and foresees the equality body collecting different types of data. Obviously, they will have to provide and collect and provide data on their own activities, which I think is a standard process for any kind of public institution. They will have their own statistics of complaints and so on. But the directive requires them to go further, and they also can access statistics and data about equality collected by others, and they can also make and conduct their own research and surveys. So it is seen as a very, very important tool for equality bodies, I think. And what's more, as I alluded to it already, the equality bodies will be expected to publish a report and recommendations at least every 4 years on the state of equal treatment and discrimination, including potential structural issues in their member state. So basically, every 4 years, we would have, for every European country, we would have a report on the state of discrimination in the country. We would be able to see what are the most important issues and how to tackle them. This would definitely help us to see how to tackle them. Of course, I think you are also completely right in that in any kind of process in front of the courts as well, I think it's more and more accepted that equality data can be used. So if, for instance, you have a case of equal pay, or if you have a case of racial discrimination in education, then you can bring evidence that, look, the pay gap in our country is this or that. In this sector that we are talking about, it is particularly bad. That can strengthen the case, and it can sort of underpin the case, and it can help to shift the burden of proof to the respondent. The same with, let's say, segregation in education. If there is a lot of data about certain minorities, racial minorities, for instance, being consistently put in different classes, that can help your case in an individual case as well. Now, I think that ex officio is a really, really important part of, or should be a really, really important part of every equality body's mandate and work. Turkey is by no means the only equality body that, or the only country that doesn't give the equality body powers to act ex officio, but I think it's very clear that there are certain types of issues which simply just cannot be successfully tackled without the tool of ex officio investigations and decisions or litigation in their own name. Because, for instance, and here we can go to examples. You can think of, for instance, gender pay gap is a thing that is typically something that comes from a complainant who realizes that their pay is lower than someone else's or another category. But then there are other types of cases, and one really good example is also quite fashionable nowadays is artificial intelligence. If there is discrimination by artificial intelligence systems, quite often an individual is not going to be able to even recognize that. So I think it's either going to be a lot of individuals coming together and taking a class action type of claim, or the equality body, for instance, getting knowledge of this from the media and then acting on it because there is no individual victim in the case. Another quite typical issue when ex officio is really necessary is when discrimination happens in the media or through the media. There are examples for this when certain employers or potential employers, rather, were making statements about not accepting certain types of individuals, for instance, of Moroccan origin in a Belgian case, or homosexuals in a Romanian case. And they were making this statement on radio, television, or newspaper that they are never going to accept as a worker, or as the Romanian case was, a football player, someone with a Moroccan origin or with a homosexual sexual identity, sexual orientation. And in such a case, you don't have actually one victim, but there are a lot of potential victims. And in such a case, the equality body can really take up such a case and take it ex officio against the person who made that statement. And this has also been tested in front of the Court of Justice of the EU. It is a possibility to bring these kind of claims forward, even in the absence of an individual victim. So ex officio, in short, is really important. And unfortunately, it is not going to be a requirement for all member states to give the power for their equality bodies to act in their own name, but it is one of the types of powers that they can decide to give the equality bodies. So it's going to be basically a menu from which the countries, the member states, will have to choose, and they may choose, among other things, to give equality bodies the power to act in their own name. And let's hope that many or most of them will do that. In terms of the elections, I think that that's also another really typical and good example of situations where ex officio would be quite useful, because if a politician or a candidate says something at a rally, political rally, that is discriminatory or harassing towards certain persons or certain groups of persons, then the equality body can plausibly take up this case and take it to court, or make their own decision about it if they would like that. And then beyond that, beyond the use of these hard legal powers, I think it's also important to mention that some equality bodies also use their power to give recommendations or to make public statements to call for election campaigns that are respectful of minorities and are not discriminatory and do not engage in hate speech. In that respect, actually, EQUINET also produced a set of recommendations in 2019 on combating discrimination and hate speech in election campaigns. Incidentally, this is also translated into Turkish. So I am going to share the link to that in the chat if you don't have it. But it's it's essentially a call for everyone to be respectful and avoid discrimination. It's we decided to do this because we felt that it could actually be a useful thing for equality bodies to do, and a non-political thing, because of course equality bodies should not engage in politics, so they should ideally try to avoid taking sides in political debates, but asking for no discrimination and no hate speech in an election campaign, I think is a completely legitimate task of the equality body. I shared
Evet, bizim örneğimizde resmen inceleme etkisi var aslında, ama başvuruyu kabul etmedi ve resmen inceleme yapmadı gibi bir sorun olmuştu diye söyleyeyim. Şimdi ikinci soru var, onu hemen sorayım. AB ülkelerinde eşitlik kurumları ile yargı organları arasında nasıl bir ilişki oldu? Özellikle de bağlayıcı karar alma yetkisine sahip olanlar bakımından bu ilişki nasıl şekilleniyor diye soruyor katılımcı.
Çiğdem, the interpreter is asking you to repeat the question, please.
Yan tarafta var Işıl bu arada. AB ülkelerinde eşitlik kurumları ile yargı organları arasında nasıl bir ilişki var? Özellikle de bağlayıcı karar alma yetkisi varsa.
Okay, so as I said, it's one possible model. It's one possible model for equality bodies to have legally binding decisions. It's a small minority of equality bodies within the EU. There are many equality bodies that take decisions on complaints in front of them, but typically they do that in an ombudsman-like way. So it's typically those kind of institutions which also have an ombuds function. And in that kind of cases, the decision is not legally binding. It's basically recommendations. Now, in some countries, and I'm aware of that being the case in Hungary, Romania, and Bulgaria, so relatively new member states, they decided to give the equality body legally binding decision-making functions, which also comes with sanctioning power. And as Çiğdem mentioned, I used to work at the Hungarian equality body, so I have first-hand experience of how that works, at least in that country. It's basically on a complaint. The way Hungary implemented the EU legislation was that they set up this quasi-judicial body, which is in a way parallel it's a parallel route to the judicial route. So any victim of discrimination can decide whether they turn to the courts or they turn to the equality body. And there are advantages to both. Namely, and most typically, the process of the equality body is going to be quicker. And it's also an institution that is dedicated to deal with equality issues, whereas in the courts, I am hoping it's not the case in Turkey, but I would imagine it is the case in most countries that the judges, who have many other things to do and many other fields of law to know, they are not experts necessarily in equality law. So, you have maybe a better chance to get your problem understood if you go to the equality body as a specialized institution. On the other hand, of course, the equality body is not able to provide or to grant compensation or damages to the victim of discrimination. In all three of these countries, they can issue sanctions, but they are punitive sanctions, essentially administrative type sanctions. So they can, besides finding that discrimination took place and giving they can give a warning in some countries, or they can reprimand the discrimination that happened. They can also provide administrative fines, several thousands of euros worth of fines. They can also publish the decision on their own website, or they can also publish it in newspapers, for instance, or media. So there are different, quite strong sanctions that can be imagined, but they are administrative type sanctions. And then, of course, in terms of the relationship, the legally binding decision of the equality body can always be appealed to the court system, just to ensure the right to turn to court and due process. So it is always possible to appeal the equality body's decision to the court, but if it's not appealed, then it's legally binding and fine.
Evet, belki Türkiye ile ilgili ben de kısa bir bilgi verebilirim. Türkiye'de hem KDK tavsiye karar veriyor, hem de TİHEK bağlayıcı idari yaptırım kararı verebiliyor. Böyleyim. Kamu Denetçiliği Kurumu'nun kararları mahkemelerde bir ispat aracı olarak kullanılabiliyor en fazla. Buna karşılık TİHEK kararlarına karşı idari yaptırım kararıysa suç cezaya, eğer ret yönünde ise idare mahkemelerinde dava açılabiliyor. Örnekleri de oldu. Türkiye'de bunların tamamı örnek olarak oldu. Evet, gelen bir başka soruyu söyleyeyim hemen. Belçika ile ilgili, engelli hakları ile ilgili özel bir yapı olduğundan bahsettiniz. Bununla ilgili bilgi verir misiniz diye bir soru gelmiş.
So in Belgium, it's the equality body. In Belgium, they have two equality bodies. One of them deals with gender equality and equality on gender identity and expression and sex characteristics. And then the other one deals with all other forms of discrimination. So there is no dedicated structure for disability. Within our network, we have dedicated equality bodies on disability in Austria, in Croatia, and in Malta. So, like I said, the three grounds which I know of that in some countries they have dedicated equality bodies are gender and disability, and I think in one or two countries race or ethnic origin, but mainly gender or disability. In some countries they decided to set up a dedicated structure. I think it's mainly because of the CRPD, the UN Convention on the Rights of Persons with Disabilities, requiring every state party to establish an independent monitoring mechanism. So I think the sort of privileged status of disability or privileged attention to disability is probably due to the CRPD.
Evet, bir başka soru aslında bir diğeriyle de ilişkili. Eşitlik kurumlarının dava açma hakkına sahip olduğundan bahsettiniz. Bunu detaylandırır mısınız diye bir soru var. Bir de hemen peşine tabii Türkiye'de sivil toplum örgütlerinin doğrudan başvuru yapma yetkisi yok. En fazla ihbar olarak nitelendiriyor. Bu konuda direktifler ne içeriyor şeklinde. Türkiye'deki uygulamayı da ben hemen ekleyerek söyleyeyim, daha doğrusu mevzuatı. TİHEK Türkiye'de ancak bir mahkeme bu konuda bir talepte bulunursa bir davaya katılma yetkisine sahip. Onun dışında dava açma ya da davaya kendiliğinden katılma gibi bir yetkisi yok. diye de bilgi vermiş olduk. Buyurun.
Okay. So in terms of litigation, as I mentioned, the directives foresee that all equality bodies, and I'm now talking about the agreed text. So I'm not talking about the Commission proposal, but the text that was agreed yesterday. So what is likely to be the adopted directives. So every member state will have to grant amicus curiae powers to their equality bodies. So they should all have the right to go to the to make observations to the court, and then they can choose from proceeding in the name of the victim, in support of the victim, or on their own behalf. So out of these three powers, every member state will have to give at least one of these powers to the equality body. So either in the name of the victim, representing the victim, or in support of the victim, essentially intervening on the side of the victim, or own name procedure. Every equality body would have to have at least one of these three powers. And then in terms of the right of NGOs to turn to the court, that should also be possible according to the EU legislation.
Evet, bir başka soru, kadın ve LGBT artı bireyler açısından hem hukuksal yardım hem de hatta duygusal ve psikolojik destek gerekmez mi diye bir soru. Özellikle yani anladığım kadarıyla hükümetlerin siyasi tercihleri bu tür ayrımcılıkları desteklediği durumda bu tür dezavantajlı grupları korumak için etkin yaptırım ne olabilir diye bir soru gelmiş.
Yes, so of course, equality bodies should also provide support to the victims of discrimination that goes beyond just giving them legal advice. It's also the directives they foresee that the equality bodies should also inform at least the victims about the forms of psychological or other types of relevant support that is available. So it's not necessarily expected of the equality bodies to provide all these services themselves, but to be able to direct the victims of discrimination to such services that is expected from them. And I think it's fair to say that in practice, many or most equality bodies actually do provide, and the colleagues, the individuals working in the equality bodies, they do provide such help and services to the victims of discrimination. I think that I can say with relative certainty that people working in equality bodies are typically there because they believe in what they do, so they are not going to do the sort of typical bureaucratic, I'm sorry, I cannot deal with this because it's not in my mandate kind of responses. Even if they cannot deal with it because of the limitations of the mandate, they try to give some solutions and try to help the victim to find some solutions to their problems.
Evet, bir başka soruda EQUINET üyesi eşitlik kurumları BM komitelerinde kendi ülkelerindeki insan hakları durumu hakkında devletten bağımsız raporlama yapıyor mu? Zannediyorum buradaki vurgu devletten bağımsız, yani biraz o bağımsızlık işleriyle ilgili. Bilgi olarak mesela son Çocuk Hakları Komitesi'nde Türkiye'de KDK ve TİHİK rapor verdi. Bir örnek olarak da onu söyleyeyim şimdi.
Yes, it's quite typical. I think I can say it is almost in the DNA of those equality bodies that are also NHRIs, but not just them. I think it's quite widespread that equality bodies provide information to the treaty bodies, especially those that are of immediate relevance. The CEDAW Convention, the CERT Convention, the CRPD Convention comes to mind, which equality bodies really, really regularly contribute to.
Evet, süremizi de aştık. Çevirmenimizde yorduk ama son bir soru. Eşitlik kurumları savaş ve silahlı çatışma süreçlerinde nasıl bir işlev üstlenebilir? Dünyada da bitmeyen bir gündem olarak. Buyurun.
So last October, 2 months ago, we welcomed a new member in EQUINET, the Ukraine Parliamentary Commissioner for Human Rights, which also has an equality body mandate. And there, I think it's quite a good illustration of equality bodies, quite a good and sad illustration of an equality body working in a really, really difficult context of war. I think to a certain extent, the example of the Ukraine commissioner, I mean, it's a great illustration of how there are some completely new problems that the equality body has to deal with during times of war. When it comes to, for instance, the internally displaced persons or the rights of children to education who are internally displaced or who have lost their families. And then there are also some of the issues which are actually not new, and just because of a war happening, they unfortunately didn't go away, because gender discrimination or sex discrimination is still happening. Discrimination against Roma is still happening, and in certain ways it can even get worse. So we as EQUINET, we don't have a dedicated project to look into that, but we know that this is the case in Ukraine, for instance, and I think that equality bodies really have a very important role to play in times of crises as well. They also demonstrated that during the COVID-19 pandemic, when equality bodies were really active, looking at issues, new issues that came up, and how persons with disabilities were disadvantaged, or older persons were disadvantaged by state policies as well, and so on. So I think that they are really there to remind the state that equality is not just a luxury, but it's a necessity also during times of crisis.
Evet, çok teşekkür ediyoruz. Sorularımız var, evet. Mesele gerçekten çok can alıcı mesele Türkiye'de de. Katılımınız için çok teşekkür ediyoruz. Çok aydınlatıcı dediğiniz için. Ayrıca katılımcılarımıza da teşekkür ederek oturumu kapatalım isterseniz. Herkese iyi akşamlar diliyoruz.